Okay, Rule 6 Kinds of Pleadings. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Section 1, Rule 6. What are the pleadings allowed by the rules of court? The pleadings allowed by the rules of court are the complaint, counterclaim, cross-claim, third-party complaint, complaint in intervention, answer, and reply. Our keyword will be 5-CAR. Note that under the rules on summary procedure, the only pleadings allowed are the complaint, the compulsory counterclaim, the cross-claim, and the answers thereto. 3CA. An answer may be responded to by reply only if the defending party attaches an actionable document to the answer. So what is a complaint? A complaint is the pleading alleging the plaintiff's or claiming party's cause of or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. How about an answer? An answer is a pleading in which a defending party sets forth his defenses. What are the kinds of defenses? Defenses may either be negative or affirmative. A negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant essential to his cause or causes of action. An affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the claimant's pleading, would nevertheless prevent or bar recovery by him. That is Section 5. Give examples of affirmative defenses. Fraud, prescription, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Affirmative defenses may also include grounds for the dismissal of a complaint, specifically that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment. Section 5, letter B. Second paragraph. Question. Plaintiff files a complaint against B, C, who, or against B and C, who are made co-defendants. C files an answer serving a copy thereof upon P. The C also need to serve a copy upon B. The answer is no. A co-defendant does not need to serve a copy of the answer against a co-defendant, except where there is a cross-claim in the answer or in case of Section 5, Rule 62, in interpleader, where the conflicting claimants should serve a copy of the answer on their co-defendants. Counterclaim. What is a counterclaim? A counterclaim is any claim which a defending party may have against an opposing party. How is a counterclaim set up or pleaded? May a counterclaim be set up in a motion to dismiss? While technically a separate and independent pleading, a counterclaim by common practice is pleaded or set up in an answer. Thus, the practice of denominating such an answer as answer with compulsory or permissive counterclaims. A counterclaim cannot, however, be set up in a motion to dismiss. The reason is that unlike in the case of an answer, at Section 8, Rule 11, there are no provisions in the rules which provide that counterclaims may be set up in a motion to dismiss. P files a case against D. D files a counterclaim against P. May P file a counterclaim against D's counterclaim? The answer is yes. A counterclaim may be asserted against an original counterclaim. Question. The Republic, through the PCGG and with the assistance of the Office of the Solicitor General, filed with the Sandiganbayan a complaint against Cojuangco and Enrile for conveyance and damages. Subsequently, Enrile was granted leave of court to implead Solicitor General Chavez as a defendant in a counterclaim for filing a harassment suit. Was the filing of a counterclaim against Solicitor General Chavez proper? The answer is no. A counterclaim is any claim which a defending party may have against an opposing party. Chavez was not the opposing party but merely the counsel of the opposing party, and really has to file a separate suit if he wants to claim damages against Chavez. That's in the case of Chavez versus Sandiganbayan, 9193-282. Q. PX filed a suit for damages against DY. In his answer, DY incorporated a counterclaim for damages against PX and AC, counsel for plaintiff in said suit, alleging in said counterclaim, inter alia, that AC, as such counsel, maliciously induced PX to bring the suit against DY despite AC's knowledge of its utter lack of factual and legal basis. In due time, AC filed a motion to dismiss the counterclaims against him on the ground that he is not a proper party to the case, he being merely plaintiff's counsel. Should AC's motion to dismiss the counterclaim be granted or not? Yes, AC's motion to dismiss the counterclaim should be granted, as held in Chavez v. Sandiganbayan, 193-282. The lawyer of the opposing party is himself not a party to the case, and thus the counterclaim is not proper against him. DY should file a separate suit against AC. Is there an instance wherein a counterclaim may be asserted by the defending party against one who is not an opposing party? Yes. Under Section 13, Rule 6, a third-party defendant may in proper cases assert a counterclaim against the original plaintiff in respect of the latter's claim against a third-party plaintiff. There is an illustration under Section 13, Rule 6. Q. What are the kinds of counterclaims? A counterclaim may either be compulsory or permissive. Define a compulsory counterclaim and a permissive counterclaim. A compulsory counterclaim is one which arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim and complies with the other requirements set forth in Section 7, Rule 6. A permissive counterclaim is one which is not a compulsory counterclaim. So, distinguish a compulsory counterclaim from a permissive counterclaim. Mnemonics would be SC-PAD. That is number 1. As to preclusion if not raised, a compulsory counterclaim not set up in an action shall be deemed barred, while a permissive counterclaim is not barred even if not set up in the action. Number 2. As to payment of filing fees. Payment of filing fees in compulsory counterclaims has been suspended, while filing fees need to be paid on permissive counterclaims filed with the RTC. As for need to answer, a compulsory counterclaim, as a rule, need not be answered, while a permissive counterclaim should be answered. Otherwise, the plaintiff could be declared in default in respect thereof. Number 4. As for prohibition against the rule on summary procedure, a compulsory counterclaim is allowed under the rule on summary procedure, unlike a permissive counterclaim, which may not be availed of therein. Number 5. As for requirement of certification against forum shopping, a compulsory counterclaim need not be accompanied by a certification against forum shopping, while a permissive counterclaim must be so accompanied. Spouses Ponciano versus Parentela, GR number 133284, May 9, 2000, or Alba versus Malapajo, January 13, 2016. Section 16. Compulsory Counterclaim. Why is a compulsory counterclaim termed as such? A compulsory counterclaim is termed compulsory because there is an element of compulsion to set it up. Section 7, Rule 6 provides that a compulsory counterclaim not raised in the same action is barred unless otherwise allowed by the rules of court. Under Section 2, Rule 9, a compulsory counterclaim not set up shall be barred. What is the reason behind Section 2, Rule 9? The rule is designed to achieve resolution of the whole controversy at one time and in one action and to avoid multiplicity of suits. Buckline v. Court of Appeals, 182 SCRA 761. Or under Ledesma v. Morales, 87 Phil 199. How should a compulsory counterclaim or cross-claim be set up? A compulsory counterclaim or cross-claim that a defending party has at the time he files his answer shall be contained therein. Section 8, Rule 11. Should a defendant who has a compulsory counterclaim file a motion to dismiss? The answer is no. The Supreme Court has stated that if the defendant has a compulsory counterclaim, he should not file a motion to dismiss but an answer with a counterclaim, with the ground for the motion to dismiss being asserted as an affirmative defense pursuant to Section 6, Rule 16. Financial Building Corporation versus Forbes Park Association, GR number 133119, August 17, 2000. Q. What are the requirements in order that a counterclaim may be considered compulsory? The keyword is Jarrett. Number 1, it must be recognized by a regular court of justice. Number 2, it arises out of or is connected to the transaction or occurrence constituting the subject matter of the opposing party's claim. Number 3, it does not require for its adjudication the presence of third parties over whom the court cannot award jurisdiction. Number 4, it must be within the jurisdiction of the court, both as to the amount and the nature thereof. Exception: in an original action before the RTC, the counterclaim may be considered compulsory, regardless of the amount. Number 5, it must be existing at the time the defendant files his answer. That is under Section 7, Rule 6, Section 8, Rule 11. Banco de Oro Universal Bank versus Court of Appeals. Q. What is the meaning of transaction or occurrence under Section 7, Rule 6? The word transaction or occurrence, as used in Section 7, Rule 6, includes the facts out of which a cause of action may arise. Manuel versus Moran, Comments on the Rules of Court, 1979 edition. Q. What are the tests devised by the Supreme Court to determine whether a counterclaim is compulsory or not? A. To determine whether a counterclaim is compulsory or not, the Supreme Court has devised the following test. Keyword: LIRE. L-I-R-E. Letter A. Are the issues of fact and law raised by the claim and by the counterclaim largely the same? Letter B. Would res judicata bar a subsequent suit on defendant's claims absent the compulsory counterclaim rule? Letter C. Will substantially the same evidence support or refute plaintiff's claim as well as the defendant's counterclaim? And finally, is there any logical relation between the claim and the counterclaim? A positive answer to all 4 questions would indicate that the counterclaim is compulsory. GSIS versus Caballero, GR 158090, October 4, 2010. Q. What is the compelling test of compulsoriness to determine whether a claim is compulsory? The test involves asking the question whether there is a logical relationship between the claim and the counterclaim, that is, where conducting separate trials would entail a substantial duplication of effort and time by the parties and the court. If there is such a logical relationship, then the claim is compulsory. Tan versus Kakbay Finance Corporation, GR 146595, June 20, 2003. Note, from an analysis of Supreme Court decisions, a rule of thumb that may be used is the test of opposition or inconsistency. Would the grant of the complaint necessarily defeat or negate the counterclaim? Alternatively, would the grant of the counterclaim necessarily defeat or negate the complaint? If the answer is yes, then the counterclaim is compulsory. If no, then the counterclaim is permissive. Q. Plaintiff filed a suit for nullification of a promissory note against the defendant on the ground of usurious and unconscionable interest rates. The defendant counterclaimed for the payment of the 1 million loan with interest. He, however, did not pay the docket fees. Should the counterclaim be dismissed for failure to pay docket fees? No. The counterclaim for the payment of the loan with interest is compulsory since it arises out of or connected to the loan transaction subject of the complaint. The grant of the counterclaim would necessarily negate or defeat the suit for nullification. Being compulsory, there is no need to pay the filing fees thereon. Tan versus Kakbay Finance Group, GR 146595. And Alba versus Malapaho, 13 January 2016. Q. Should filing fees be paid on compulsory counterclaim? The answer again is no. While compulsory counterclaims are subject to filing fees, the payment thereof has been suspended by the Supreme Court. The old rule was that filing fees were required of permissive but not compulsory counterclaims. Section 7, letter A, Rule 141. Section 7, letter A was later amended on August 16, 2004, so as to impose filing fees also on compulsory counterclaims filed before the RTC. Payment, however, of such filing fees was suspended by the Supreme Court resolution dated September 21, 2004. Confusion later arose from the obligatory dictum in Korea Technologies Corporation versus Lerma 542 SCRA, which stated that effective August 16, 2004, under Section 7, Rule 141 as amended by Administrative Order or Number 04204 Supreme Court, docket fees are now required to be paid in compulsory counterclaim or cross-claim. That is AM number 04204 SC. As a result, some courts were collecting filing fees on compulsory counterclaims, citing Korea Technology Company Limited. The obligor clearly overlooked the Supreme Court resolution of 21 September 2004. Thus, the Supreme Court's Office of the Court Administrator issued a clarificatory circular stating that the obiter dictum has been deleted in a revised issuance and that the resolution of this court in AM number 04204 SC dated September 20, 2004, suspending payment of filing fees for compulsory counterclaims remains in effect. That is under OCA Circular Number 962009, dated August 13, 2009. Note, however, that the payment of filing fees on cross-claims was not suspended. Q. Fernando mortgaged his land and building to the GSIS to secure a loan he obtained from the latter. Fernando defaulted on his loan, so the GSIS foreclosed on the loan and later acquired it at the foreclosure sale. GSIS consolidated its title over the realty after the lapse of the redemption period. Subsequently, GSIS awarded the realty to CMTC after public bidding in which Fernando also participated. Fernando then filed a suit with the regional trial court against GSIS and CMTC for nullification of the bid award to CMTC and for the declaration of his own bid as the winning one. GSIS filed an answer with counterclaim for the recovery of rentals from the realty which Fernando had been collecting from CMTC despite the consolidation of title by the GSIS. GSIS did not pay any filing fee on the counterclaim. After trial, the RTC dismissed Fernando's complaint and granted GSI's counterclaim for rentals. On appeal, the Court of Appeals affirmed the dismissal but deleted the award of rentals in favor of the GSIS. Is the counterclaim of GSIS for rentals a compulsory or a permissive counterclaim? Did the CA rule correctly in deleting the award of rentals to GSIS? Answer to letter A, the counterclaim of GSIS for rentals is a permissive counterclaim. One of the tests devised by the Supreme Court is to ask whether substantially the same evidence will support or refute plaintiff's claim as well as the defendant's counterclaim. A negative answer, as in this case, means that the counterclaim is permissible. The evidence needed by Fernando to cause the annulment of the bid award and the sale of CMTC is different from that needed by GSIS to establish its claim for the recovery of rentals. A favorable judgment on Fernando's complaint to nullify GSI's bid award to CMTC would not preclude a favorable judgment for GSIS on its counterclaim to recover the rentals which Fernando had been collecting from CMTC after GSIS had become the owner of the property. Letter B. Yes, the CA acted correctly in deleting the award of rentals to GSIS. The rule in permissive counterclaims is that for the trial court to acquire jurisdiction, the counterclaimant is bound to pay the prescribed filing fees. Since the GSIS failed to pay the filing fees, the RTC did not acquire jurisdiction over its permissive counterclaim. The judgment rendered by the RTC insofar as it ordered Fernando to pay GSIS the rentals which he collected from CMTC is considered null and void. Any decision rendered without jurisdiction is a total nullity and may be struck down at any time, even on appeal. GSIS versus Caballero, GR 158090, October 4, 2010. Q. Aya sues Leah for recovery of a tract of land. Leah seeks in turn to be reimbursed of the value of improvements she had introduced on the same land and the payment of damages she has sustained. Should Leah file a separate action against Aya for that purpose? The answer is no. Leah should not file a separate action against Aya for that purpose. Under Section 2, Rule 9, a compulsory counterclaim not set up shall be barred. Hence, the claim of Leah for reimbursement of the value of the improvements she had introduced on the same land and the payment of damages she had sustained in the compulsory counterclaim, since it arises out of or is connected to the suit of Aya for recovery of land. The favorable judgment on Leah's counterclaim would negate Aya's suit for recovery, since Leah would have the right of retention under Article 546 of the Civil Code. Hence, Leah should set up her claim for reimbursement and damages as a compulsory counterclaim against Aya. Camara versus Aguilar, 94 Phil 527. Calibre Traders entered into a distributorship agreement with Bayer Philippines for the distribution of Bayer chemical products in Pangasinan and Tarlac. Under the agreement, Calibre was entitled to rebates and discounts. The parties later on had a disagreement as to the amount of the rebates and discounts. Alleging abuse of right, Calibre Traders filed an action for damages with the regional trial court against Bayer for breaching its obligations under the distributorship agreement by refusing to reconcile accounts and by appointing other distributors in Pangasinan and Tarlac. Bayer filed an answer with counterclaim for unpaid accounts under the distributorship agreement. Calibre filed a motion to dismiss the counterclaim on the ground that it was permissive and Bayer had not paid the docket fees thereon. Bayer opposed the motion, arguing that its counterclaim was compulsory. The trial court denied the motion to dismiss, stating that the counterclaim was compulsory. After trial, the court rendered judgment in favor of Calibre. In its judgment, the trial court also dismissed Bayer's counterclaim, stating that since it was permissive, the trial court did not acquire jurisdiction over the same for non-payment of the docket fees thereon. Letter A. Was Bayer's counterclaim permissive or compulsory? Letter B. Did the trial court rule properly in dismissing Bayer's counterclaim? Answer to letter A. Bayer's counterclaim was permissive. Although the rights and obligations of the parties are anchored on the same contract, the causes of action they filed against each other are distinct and do not involve the same factual issues. There is no logical relationship between the two actions in a way that the recovery or dismissal of plaintiff's suit will establish a foundation for the other's claim. The counterclaim for collection of money is not intertwined with or contingent on the Calibre's own claim for damages, which was based on the principle of abuse of right. Both actions involve the presentation of different pieces of evidence. Calibre's suit had to present evidence of malicious intent, while Bayer's objective was to prove non-payment of purchases. Calibre Traders versus Bayer Philippines, GR 161431. The grant of Bayer's counterclaim for unpaid accounts would not necessarily defeat or negate Calibre's suit for damages based on abuse of right. Answer to letter B. No, the trial court did not act properly in dismissing the counterclaim of Bayer. Bayer here was in good faith in not paying the docket fee since it relied upon the trial court's earlier order denying the motion to strike out the counterclaim and stating that the counterclaim was compulsory. What the trial court should have done was to require Bayer to pay the docket fee within a reasonable time, but not beyond the prescriptive period. Furthermore, Bayer should not suffer for the mistake of the trial court. Q. In a suit for lesser against lessee for unpaid rentals, is a counterclaim by lessee for damages against the lessor for the latter's taking over the leased premises and harvesting crops permissive? The answer is yes. The complaint and the counterclaim are not repugnant or inconsistent with each other. The fact that the lessor is entitled to unpaid rentals would not authorize him to unilaterally take over the premises and harvest the crops planted by the lessee. See Vargas versus Estate of Orgas, October 5, 2016. Q. Metrobank foreclosed extrajudicially on a real estate mortgage executed in its favor by the spouses Reynoso to secure the loan of CPR Promotions. Metrobank bought the realty mortgage at the auction sale. Subsequently, Metrobank filed an action against the Reynoses with the regional trial court to collect on the deficiency of $2.6 million. The Reynoses filed an answer where they raised the defense that the bid price exceeded the amount of the mortgage obligation. They filed counterclaims for moral and exemplary damages and attorney's fees, alleging that the suit was unfounded. The RTC rendered judgment in favor of Metrobank. The Reynoses appealed to the Court of Appeals. In their appeal brief, the Reynoses prayed for the return of the excess of the bid price over the amount due under the mortgage. The CIA reversed the RTC and ordered Metrobank to refund to CPR $722,000, representing the excess of the bid price over the amount due under the mortgage. Assuming that the bid price did indeed exceed the Reynosa's mortgage obligation, was it proper for the Court of Appeals to order the refund of the excess? The answer is no. Under Section 2, Rule 9, compulsory counterclaim not set up is barred. Here, the claim of the Reynosas for the refund of the excess over the bid price was a compulsory counterclaim since it is inconsistent with or in direct opposition to the claim for deficiency of Metrobank. Hence, it should have been set up as a compulsory counterclaim in the action for deficiency filed by Metrobank. Since it was not, the claim for refund was barred. Metrobank versus CPR Promotions, June 22, 2015. The last opportunity for the spouses Reynoso to set up their claim for refund was by amendment before judgment pursuant to Section 10, Rule 11. They could no longer set up the claim for refund on appeal. The fact that in their answer with the RTC, the Reynosas raised as a defense the excess of the bid price over the obligation will not benefit them since a defense is not a counterclaim. D borrowed $1 million from P, secured by a real estate mortgage, executed by D in P's favor. The mortgage contained a special power of attorney authorizing P to sell the real estate at the foreclosure sale. D defaulted in the payment of the loan. D filed an action against P to nullify the real estate mortgage on the ground that his wife did not give her consent thereto. Judgment was rendered in favor of P, dismissing D's complaint. Letter A. P filed an action to collect on the loan against D. Is the action barred? Letter B. Instead of an action to collect on the loan, P filed an action for judicial foreclosure against D. Is the action barred? Instead of an action to collect or for judicial foreclosure, P filed a petition for extrajudicial foreclosure against D. Is the action barred? Answer to letter A, no. Applying the opposition test, we find that the action to collect on the loan is not a compulsory counterclaim, which should have been set up by P in the action for nullification of the real estate mortgage. A judgment nullifying the real estate mortgage would not preclude P from collecting on the principal loan since the mortgage is only an accessory obligation. Answer to letter B, yes. Applying the opposition test, it can be seen that a judgment nullifying the mortgage would necessarily preclude an action to foreclose upon it. Hence, the action for judgment or judicial foreclosure is a compulsory counterclaim, which is barred since it was not set up in the nullification suit. Answer to letter C, no. The right to foreclose extrajudicially is a substantive right under Act number 3135, which cannot be repealed or abrogated by a procedural rule. Papa versus Banaan, 17 Scra, 1083. Besides a petition for extrajudicial foreclosure, being precisely extrajudicial cannot be set up as a counterclaim before a regular court. P files a suit against D before the RTC of Makati City, assuming that D's counterclaim arises out of or is connected to the transaction or occurrence constituting the subject matter of P's claim. Can D file a counterclaim for ejectment? Letter B, for sum of money, $350,000. Letter C, for support. Letter D, for infringement of D's patent. Number 5, for delivery of title over a subdivision lot which P as a subdivision developer sold to D. Letter A answer, no. A counterclaim must be within the jurisdiction of the court as to its nature. Letter B, yes. In the RTC, a counterclaim may be considered as compulsory regardless of the amount itself. The counterclaim would be governed by the regular procedure, not the rules of procedure for small claims cases. For the latter, rules apply only to cases filed before the MTC. Letter C, no, the counterclaim must be recognized or cognizable by the regular courts of justice. An action for support is cognizable by a special court, that is, the family court. Letter D. It depends. If the RTC is also a special commercial court, then the counterclaim may be filed before it. If the RTC is a non SCC, then the counterclaim cannot be filed before it, since cases involving violation of intellectual property rights should be filed with and tried by the SCCs. Letter E. No, the counterclaim is within the jurisdiction of the HLURB. Q. F or FAIR filed a collection suit for $387,000 against Ramon in the RTC of Davao City. Aside from alleging payment as a defense, Ramon, in his answer to set up counterclaims for $100,000 as damages and $30,000 as attorney's fees as a result of the baseless filing of the complaint, as well as for $250,000 as the balance of the purchase price of 30 units of air conditioners he sold to Faye. Does the RTC have jurisdiction over Ramon's counterclaims, and if so, does he have to pay docket fees thereof? The answer: the RTC has jurisdiction over Ramon's counterclaim for $130,000 as damages and attorney's fees, but it does not have jurisdiction over the counterclaim for $250,000. A counterclaim must be within the jurisdiction of the court, both as to the nature and amount. However, in an original action before the RTC, the counterclaim may be considered as compulsory, regardless of its amount. Hence, the RTC has jurisdiction over the claim of $130,000, which is a compulsory counterclaim, even though the amount thereof does not exceed $300,000. The RTC, however, does not have jurisdiction over the permissive counterclaim for $250,000, since the same does not exceed the jurisdictional amount of $300,000. Ramon does not have to pay docket fees on the $130,000 counterclaim. While Section 7, Letter A, Rule 141, as amended on August 16, 2004, imposes docket fees on compulsory counterclaims filed before the RTC, the payment of such docket fees has been suspended by the Supreme Court in its in-bank resolution. Suggested answer of UP Law Center and Philippine Association of Law Schools on the same question. Yes, the RTC has jurisdiction over Ramon's counterclaims because they are all money claims in which the totality rule applies in determining jurisdiction. Section 5D, Rule 2, Rules of Court. Note, it is submitted that the totality rule cannot be applied. This is because in the case of a compulsory counterclaim, the RTC would have jurisdiction over it regardless of its amount. Otherwise put, in a compulsory counterclaim, the amount thereof does not serve as a test of jurisdiction. Hence, the amount of the compulsory counterclaim, should not be added to the amount of the permissive counterclaim in order to determine jurisdiction. It would be, however, different in the case of two or more permissive counterclaims that are principally or for recovery of money, in which case the aggregate amount would be the test of jurisdiction. Ramon has to pay docket fees for his counterclaim, whether the counterclaim is compulsory or permissive in nature. Rule 141 of the Rules of Court has been amended to require payment of docket fees for counterclaims and cross-claims, whether compulsory or permissive. So confusing. The suggested answer overlooks the Supreme Court in-bank resolution dated September 21, 2004, which suspends the payment of docket fees on compulsory counterclaims. Q. Pilipinas Shell Petrom Corporation, Shell, filed a petition for extrajudicial foreclosure against the petitioner, who are the mortgagors, against the foreclosure sale or after the foreclosure sale. Shell filed an action for the deficiency against the petitioners with the RTC of Manila. Petitioners, in the meantime, commenced an action to annul the extrajudicial foreclosure sale with the RTC of Makati City. The Manila RTC ruled in favor of Shell. This judgment became final and executory. Subsequently, The Makati RTC ruled in favor of the petitioner and annulled the extrajudicial foreclosure sale. The Makati's RTC ruled that no auction sale was actually conducted. Filipinas Shell filed a motion for reconsideration, arguing that the Makati case should have been dismissed on the ground of res judicata. The motion was denied and Shell appealed to the CA. Should the Makati case have been dismissed? The answer is yes. The Makati case should have been earlier disallowed to proceed on the ground of litis pendentia, or once the decision in the Manila case became final, should have been dismissed on the ground of being barred by res judicata. Petitioners' claim for annulment of the extrajudicial foreclosure case should have been set up as a compulsory counterclaim in the Manila case. See Mendiola versus Philippines Shell Petroleum Corporation. Q. DNP entered into a lease contract whereby D leased room 401 to P. P was of the impression that the lease also covered the rooftop of room 442. However, D padlocked the way to the rooftop. D insisted that the lease only covered room 401 and that P's use of the rooftop was merely tolerated. P tendered the lease payment to D, who refused to accept the same. P then filed an action for consignation with the MTC against D. D then filed an answer with counterclaim for unlawful detainer against P. The Court of Appeals ruled that the raising of the counterclaim for ejectment was improper since such could not be initiated by a verified complaint pursuant to Section 4, Rule 70. Was the filing of the counterclaim improper? The answer is no. There is no rule that an ejectment suit cannot be raised in a counterclaim. In fact, the counterclaim for ejectment was compulsory since it was connected with the transaction or occurrence constituting the subject matter of the opposing claim, that is, the lease contract between D and P, Chen versus Court of Appeals. Q. P filed with the Metropolitan Trial Court of Las Piñas City a complaint against D to recover possession of a parcel of land with an assessed value of 60,000. D filed an answer. The METC tried the case on the merits and rendered a decision in favor of P. D appealed to the RTC. Assume the RTC does not dismiss the appeal and proceeds to take cognizance thereof pursuant to Section 8, Rule 40. D filed a motion to admit amended answer in which he raises a counterclaim for 250,000 against P, which arose out of the same transaction, subject matter of the complaint. May the court admit the amended answer? The answer is no. The court may not admit the amended answer with counterclaim. Under Section 7, Rule 6, a counterclaim which arises out or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in an original action before the RTC, counterclaim may be considered compulsory regardless of the amount. Here, the RTC was deciding an appealed case and not an original action. Hence, the exemptive clause of Section 7, Rule 6 does not apply, and the counterclaim may not be admitted since it falls below the jurisdictional amount of the RTC. Q. Petitioners filed with the CFI of Cebu an action for recovery of land against the private respondents. The private respondents filed an answer raising the defense of their ownership. The CFI decided in favor of the private respondents, but on appeal, the courts of appeals reversed and decided in favor of the petitioners, declaring them as the owner of the land and ordering the private respondents to vacate the premises. In the body of its decision, the Court of Appeals stated that there was no fraud or bad faith on the part of the private respondents. The Court of Appeals judgment became final and executory. The petitioners moved for the execution of the judgment before the CFI. This was opposed by the private respondents on the ground that is hearing supplementary to execute should be conducted to allow them to present evidence to prove that they are builders in good faith and to prove the value of the improvements. Letter A. Should the CFI grant the opposition of the private respondents? Letter B. May the private respondents file a separate action to recover the value of the improvements introduced by them? Answer to letter A is no. Once a decision has become final and executory, the only jurisdiction left with the court is to order its execution. To allow the supplemental hearing would be to amend or alter a final and executory judgment. Answer to letter B is no. Under Section 2, Rule 9, a compulsory counterclaim not set up is deemed barred. The claim for reimbursement of the value of the improvements is in the nature of a compulsory counterclaim since it is connected with the transaction or occurrence constituting the subject matter of the petitioner's claim. Hence, it should have been set up as a counter or compulsory counterclaim in the action filed by the petitioners against the private respondents. The private respondents' argument that they could not have raised the counterclaim for reimbursement of the value of the improvements as it would run counter to their defense of ownership is without merit. Under Section 2, Rule 8, a party may set forth two or more statements of a defense alternatively or hypothetically. Inconsistent defenses may be pleaded alternatively or hypothetically, provided that each defense is consistent with itself. Buckline v. Court of Appeals, GR 89132, February 26, 1990. Would the dismissal of the main complaint also result in the dismissal of the counterclaim pleaded therein? The answer is no. Unlike the 1967 Rules of Civil Procedure, the rule under 1997 rules is that the dismissal of the main complaint will not correspondingly result in the dismissal of the counterclaim where the defendant had already filed and served his counterclaim upon the plaintiff. The defendant has the option of prosecuting the counterclaim the same or in a separate action. That is Section 6, Rule 16, 1997 Rules of Civil Procedure, Section 2 and 3 of Rule 17. The exception would be under Section 2, Rule 17, where the defendant pleaded his counterclaim after the service upon him of the plaintiff's motion for dismissal. In such a case, the dismissal of the complaint will also result in the dismissal of the counterclaim. The reason is quite obvious. The defendant already has notice of the plaintiff's motion for dismissal at the time he pleads his counterclaim and is therefore presumed to have borne the risk of dismissal. Q. PNB filed with Pasay City Regional Trial Court an action for recovery of money with application for preliminary attachment against Globe Asiatique Realty Corporation and Delphine Lee, Case 1. The case was referred to Branch 119, and the court issued the writ of preliminary attachment against defendants. Subsequently, Globe Asiatique filed a complaint for tort against Ida Padilla, PNB officer, and Judge Gutierrez, who had issued the writ of preliminary attachment before Pasay City RTC Branch 155, that is Case 2. Defendants filed an answer with affirmative defense of lispendence. The defendant Padilla also raised in her answer counterclaim for damages against Globe Asiatique for filing a malicious and harassment suit against her. The judge in Case 2 dismissed the complaint for lack of jurisdiction, stating that it cannot interfere with the orders of the coordinate court in Case 1. It also dismissed the counterclaim of Padilla on the ground that the dismissal of the main complaint necessarily carried with it the dismissal of the compulsory counterclaim. Was the dismissal of the compulsory counterclaim correct? Letter A, no. Under the 1997 Rules of Civil Procedure, it is now explicitly provided that the dismissal of the complaint due to failure of the plaintiff to prosecute his case is without prejudice to the right of the defendant to prosecute his counterclaim in the same or in a separate action. That's Section 3, Rule 17. The effect of this amendment is to abandon previous rulings that the dismissal of a complaint carries with it the dismissal of the counterclaims. While Section 3, Rule 17 refers to dismissal of complaints due to the fault of plaintiff, it does not preclude the application of the same rule when dismissal is at defendant's instance. The court's jurisdiction over respondent's complaint is not to be confused with jurisdiction over petitioner's counterclaim. Padilla versus Globe Asiatique Realty Corporation, August 6, 2014. Q. Financial Building Corporation, or FBC, was engaged by the USSR government to construct a multi-level apartment building in Forbes Park. Forbes Park Association, or FPA, suspended all entry permits of the construction after discovering that the same would violate the subdivision's deed of restrictions. FPC filed an action for injunction and damages against FPA anchored on the contention that FPA's prohibition on the construction work was improper. First case. FPA filed a motion to dismiss on the ground that the complaint fails to state a cause of action since it is the USSR, not FPC, which was the real party in interest. The motion to dismiss was granted. The order of dismissal became final. Later on, FPA filed an action against FPC to remove the structures it had built and for damages. Second case. If you were the counsel for FPC, what would you do? If you were the counsel for FPA, instead of filing a motion to dismiss, what would you have done? That's letter B. Letter C. Assume that no motion to dismiss was filed by FPC in the second case, and the RTC rendered the decision in favor of FPA. On appeal, may the judgment of the RTC in the second case be set aside? If so, on what ground? Answer to letter A. I would file a motion to dismiss the suit of FPA on the ground of res judicata, specifically that the case or the second case should have been raised as a compulsory counterclaim in the first case. Section 2, Rule 9. The claim to demolish the structures was a compulsory counterclaim which should have been set up in the injunction case. Such a counterclaim would defeat or negate FBC's complaint for injunction, which alleged that the prohibition on construction was improper. Letter B. I would not file a motion to dismiss, but an answer and raise the ground for the motion to dismiss, that is, failure to state a cause of action, as an affirmative defense in the answer. Section 6, Rule 16. I would plead in my answer the claim for damages and removal as a counter or compulsory counterclaim. In such a case, the dismissal of the complaint would have been without prejudice to the prosecution in the same or separate action of a counterclaim pleaded in the answer, pursuant to Section 6, Rule 16. Yes, the judgment of the RTC may be set aside on the ground of res judicata, that is, letter C. Note that the defense of res judicata may be raised for the first time even on appeal. Financial Building Corporation versus Forbes Park Association, 338 SCRA 346. Q. P sues D, who moved to dismiss on the ground of prescription. The motion is granted and the case dismissed. The dismissal order became final. Then D sues P on a claim arising out of the same transaction or occurrence as P's earlier attempted claim. P defends on the ground that D's claim is precluded by his failure to raise it as a counterclaim in the first action. Is P's defense meritorious? The answer is yes. D should have not filed a motion to dismiss, but an answer interposing his counterclaim and raising the ground of prescription as an affirmative defense. Section 6, Rule 16 of 1997 Rules of Procedure. Since he failed to set up his compulsory counterclaim in the first action, the same is deemed barred. Rule 9, Section 2. Q. filed a collection suit for $387,000 against Ramon in the RTC of Davao City. Aside from alleging payment as a defense, Ramon in his answer set up counterclaims for $100,000 as damages and $30,000 as attorney's fees as a result of the baseless filing of the complaint, as well as for $250,000 as the balance of the purchase price of 30 units of air conditioners he sold to Faye. B. Suppose Ramon's counterclaim for the unpaid balance is $310,000. What will happen to his counterclaim if the court dismisses the complaint after holding a preliminary hearing on Ramon's affirmative defense? The answer is Ramon's counterclaim may be prosecuted in the same or in a separate action pursuant to Section 6, Rule 16, which provides that the dismissal of the action shall be without prejudice to the defendant prosecuting his counterclaims in the same or in a separate action. Another, under the same premise as paragraph B above, suppose that instead of alleging payment as a defense in his answer, Ramon filed a motion to dismiss on the ground at the same time setting up his counterclaims, and the court grants his motion. What will happen to his counterclaim? The answer is Ramon's counterclaim for $130,000 will be barred since it is a compulsory counterclaim which was not set up in the answer pursuant to Section 2, Rule 9. A counterclaim cannot be set up in a motion to dismiss. Same case, Financial Building Corporation versus Forbes Park Association. His counterclaim for $310,000 may still be prosecuted in a separate action since it is a permissive counterclaim. Q. Petitioner filed a complaint for consolidation of title over land sold to him by respondent under a pacto de retrosale. Respondent filed an answer with counterclaim asking the petitioner receive $810,000 and that the pacto de retrosale be declared as an equitable mortgage. Petitioner did not file an answer to the respondent's counterclaim. Upon motion, the trial court declared petitioner in default as to respondent's counterclaim and rendered judgment in favor of respondent. Did the trial court properly declare petitioner in default in respect of respondent's counterclaim? The answer is no. The counterclaim of respondent is compulsory since it is connected with the subject matter of petitioner's complaint for consolidation. A party cannot be declared in default for failing to answer a compulsory counterclaim because the issues raised in the compulsory counterclaim are deemed automatically joined by the allegations of the complaint. Goho versus Goyola, 35 SCRA 557. Q. Plaintiff filed a complaint against defendant for recovery of possession of real property with the Regional Trial Court of Manila. Defendant filed an answer with affirmative defenses and interposed a counterclaim for damages and attorney's fees arising from the filing of the complaint. When plaintiff filed to file an answer on the counterclaim, defendant moved to declare him in default. Notwithstanding notice of the motion, plaintiff did not file an opposition. As judge, how would you resolve the motion to declare plaintiff in default? Answer. As a judge, I would deny the motion to declare plaintiff in default. The Supreme Court has held that a party cannot be declared in default for failing to answer a compulsory counterclaim since the issues in such counterclaim are automatically traversed by the complaint. Here, the counterclaim for damages and attorney's fees arising from the filing of the complaint is a compulsory counterclaim since it arises from the filing of the complaint by the plaintiff. Hence, plaintiff cannot be declared in default. Q. L obtained a series of loans from Banco de Oro for which he executed 3 real estate mortgages. L defaulted on the third loan and the bank extrajudicially foreclosed the mortgage on the first and second loans or on the first and third loans. Before the scheduled public complaint for specific Before the scheduled public auction, L filed with the RTC of Quezon City a complaint for specific performance, torts, and damages against the bank for including the first real estate mortgage in the foreclosure. The bank filed an answer in which it raised the defense that there is a cross-default provision in the loan contracts that justifies the inclusion of properties in the first real estate mortgage in the foreclosure. The auction sale then proceeded, but the proceeds realized therefrom were not sufficient to answer for L's loan obligation. The bank sent a demand letter to L to pay the deficiency, but this was not heeded by L. Subsequently, during the pendency of the Quezon City case, the bank filed with the RTC of Mandaluyong against L an action for collection of the deficiency. L filed a motion to dismiss on the ground that the action for the deficiency was a compulsory counterclaim that should have been set up in the Quezon City case since it arose from the same loan transaction. Should L's motion to dismiss the action for the deficiency be granted? The answer is no. The action for the deficiency does not involve a compulsory counterclaim. A compulsory counterclaim is one which must be existing at the time of filing the answer. Section 8, Rule 11. An after-acquired counterclaim is merely permissive. Thus, a party who fails to file a counterclaim arising out of or connected with the transaction subject of the plaintiff's suit, but which did not exist at the time said party files his answer, is not barred from filing such claims. He can do so by supplemental pleading or by a separate action. Here, BDO's right of action accrued only after L's refusal to pay after receiving demand letters for the deficiency from BDO. BDO versus Loxin, 25 August 2005, Carpio Morales.